Many families ask us the same question. If our parents have strong family ties in Canada, won't that work against their super visa application? For years, some visa officers indeed treated close family connections in Canada as a risk factor, assuming parents or grandparents might overstay. Today, I want to explain why that logic is flawed, what a recent federal court decision confirmed, and how this directly affects super visa applications. Let's start with the basics. The super visa was created specifically for parents and grandparents of Canadian citizens and permanent residents. Its entire purpose is to allow long-term family reunification, to let parents spend extended time with their children and grandchildren, to support families who have built their lives in Canada. So the idea that strong family ties in Canada automatically means someone won't leave does not make sense. In fact, family ties are not a weakness of a super visa application. They are a foundation of it. Recently, the federal court reviewed the super visa refusal involving parents from Afghanistan in this case. They met the financial requirements. They had Canadian resident son and grandchildren. Yet the officer refused the application, arguing that close family ties in Canada reduced the likelihood that parents would leave at the end of their stay. The court disagreed. Very clearly, the judge stated that treated family ties as negative factor without additional justification is unreasonable and contradicts the purpose of the super visa program itself. In simple terms, you cannot design a program of family reunification and then penalize people for having family in Canada. This ruling is extremely important for families and for how super visa applications should be assessed. Of course, this does not mean that super visas are automatic. Applicants still need proper financial support, medical insurance, credible documentation, and clear explanation of temporary intent. But what it does mean is this: strong family ties in Canada should not, on their own, be used as a reason for refusal. If an application is refused mainly because parents have children, grandchildren in Canada, that refusal can be challenged, reconsidered, and corrected. This decision gives families a stronger legal foundation when preparing application or responding to the refusals. Even with clearer court guidance, outcomes still depend on how applications are prepared. Visa officers review written explanations. They assess structure, consistency, and credibility. They look at how intent is demonstrated, not just documents uploaded. A well-prepared super visa application anticipates concerns and addresses them before they become refusal reasons. That is where experience and strategy matter. At Anyvisa, this is exactly what we do. We help families structure their super visa applications clearly, lawfully, and strategically, taking into account current court decisions, officer reasoning patterns, and program intent. If you are planning a super visa application or if you're dealing with a refusal, we recommend booking a consultation so your case can be assessed properly and individually. Every family situation is different, and a structured approach can make all the difference. As always, if you know someone who can benefit from this video, don't forget to share it. Like, subscribe to our channel so we can deliver more interesting content to you, our dear audience. And of course, stay safe by staying informed.